lock the money up, and if you need it, you're going to have to pay extra to get it out.
Right. So a couple of additional thoughts related to this. One is when you have a person other than the spouse who inherits the account, when you're computing the life expectancy each year for the distribution, you take the life expectancy at the year of death, and then you just subtract 1 from that each year if it's somebody other than the spouse.
Correct.
If it's the spouse, then you get to recalculate it. You get to look it up on the table each year.
Yes.
And then if they take it as their own, you can even do it on a 2-life basis. So
Right.
it's kind of a nice advantage there. But like you said, a big thing is that people do these knee-jerk self-administration, we call it, steps, and they will automatically go and roll that over without talking to anybody.
Right.
And if you have a young spouse, like you said, now they're stuck. They can't get the money out.
I have to tell you, in every situation that I've personally dealt with in my office where I had a young spouse, the plan administrator had assumed that it was going to be a rollover.
Mm-hmm.
And in each of those situations, it was very different. You know, the ones that really struck me were the ones that have kids who are going to be going to college.
Oh, yeah.
You know, they need access to those funds, and they can't afford to be paying a 10% penalty to get access to those funds.
Right.
So it's really, I can't stress enough how important it is to get some guidance and understand the rules on how these work in each situation.
Okay. The good news is, although I may not be able to say some of these questions, we're sort of covering them along the way. So I'm going to go ahead and sort of jump a little bit. Can a beneficiary roll over an employer retirement account? So we're not talking about an IRA. Now we're talking about a regular employer account to an IRA of their own.
So you're talking like a 401k.
Yes.
So if I'm going to keep using myself as an example, because so my husband's employed,
yes.
and so his retirement account is a 401k
Right.
because he's still working there. So he's employed, he passes away, and we've got this 401k, and he names his children as the beneficiaries. Can they do a rollover? That's the question.
Yes, yes.
They can do something that is termed a rollover very loosely, termed a rollover. It's not the same thing as a spousal rollover.
Right.
What they can do, which is new in the law, is they can take that account that's with the employer in the employer's plan, the 401k, and they can do what's called a trustee-to-trustee transfer, where the beneficiary doesn't touch the money,
Right.
and those funds are transferred to another plan administrator into an IRA. So the beneficiary doesn't touch the money, but it's a really great option, and the employers are required to offer this as an option now, so that if the beneficiary is not happy with where the funds are, maybe they have their own stuff at Schwab or Fidelity or whomever they have it with, they can take that and have it wire transferred and rolled into an inherited IRA account with another institution. It's not a rollover account like the spouse who gets to take it in their own name. it's an inherited account, but
Right.
they've been freed up to move it to a new institution.
Yeah, so it's a great new thing that's been made available just in the last few years. And again, one of the big changes that was just recently enacted, as Naomi said, is that employers are required to offer this alternative now to the beneficiaries.
And this is huge because the employers don't want to keep managing this account.
Oh, yeah.
For somebody who's they don't have an employee associated with it anymore. The employers don't want this. And so typically what the 401k plans were doing is requiring the beneficiary to take it in 5 years at the most, because they wanted to get rid of these accounts and not have to manage them. It's an extra work, extra liability, extra cost. This way, the beneficiary can still get the tax deferral advantages and do the rollover. So it's really a good thing in my opinion. And it gives us freedom of choice in the marketplace too, so that we can pick and choose who we want to administer our plans, which is good because the plans themselves can be very different. So there's the federal rules that set out the guidelines about how little you can take out.
Yes.
But the plans are really within that framework. Each plan has their own contract and has their own set of rules and has their own forms and way of doing things. And you really may want to shop around and see what you can find. They're going to, invest in, different stocks, different bonds, maybe in their own company's financial products, and maybe those aren't what you want. And to get different investment options, you can do a trustee-to-trustee transfer, move it from a 401k to an IRA, to an inherited IRA, or from one inherited IRA with one company to an inherited IRA with another company, and you can have a lot more flexibility then in dealing with these assets.
Including if you want to work with an asset manager. So I've dealt with another person here that puts together risk-managed portfolios, diversified portfolios. And so to get it into an IRA under, an account that then they can work with, it's just a real convenience. So anyway, this was a real plus. I need to move on to our next question because we're going to run out of time before we know it. And so
it's always the case when you're talking with an attorney because we can just keep talking and talking.
Yeah, well, but the other thing is this, as I said, it is a big area. Why is the Uniform Principal and Income Act a concern when a trust, especially, I'll call it a marital trust, let's call it a Q-tip trust, for the benefit of a surviving spouse, is the beneficiary of a retirement account?
Okay, so we've got this situation, right, where we'll say husband is remarried and he has kids from a prior marriage. Mm-hmm. He wants to support his wife should he die first, but he really wants to provide for his kids also. So there's this tug of war going on in the husband between his duties to the new spouse and his duties to his kids. So instead of taking this huge IRA asset and just giving it to his wife, which for tax planning purposes it's easiest and gets the best tax situation if we can just leave it outright to his wife, but then he doesn't have maybe enough to leave to his kids. So instead of just giving it outright to his wife, he gives it to her in trust. So that asset is the IRA is going to the wife inside of what we call a Q-tip trust, or a qualified terminal interest in property trust. Has lots of different tax planning and tax benefits with it. Well, when the attorney is meeting with the husband and drafting that trust and putting together the terms, oftentimes the husband will say, I wanted to support my wife, I want my wife to get the income, and I want my kids to get what's left. Well, when the husband says he wants the wife to get the income, what often is not done is that question is not, that term income is not explored. From the IRS standpoint and for purposes of the required minimum distributions, that entire required minimum distribution, that's income from a federal income tax perspective. But when you take that and you move that into the trust, the California Principal and Income Act says that 10% of that income is income for trust purposes and 90% is principal for trust purposes.
Naomi, I'm sorry I have to interrupt you, but we're actually out of time. So there is that issue, and I invite you, if you're dealing with this situation, to talk to your attorney about it. A lot of people don't know, though, that that's not all income, and so it's not all distributable is what it boils down to. Okay, folks, thank you for joining us today. Naomi, thank you for being my guest. It's such a pleasure having you here today. And I hope that we'll see you all next time on Financial Insider Weekly.
Thank you.